position.
You win if Justice Thomas's point, though, doesn't make the Commission's judgment inconsistent with the statute. Now, you have an answer to that, but there's an if, I think, that goes after what you just said.
And I'm happy to provide that answer, which is that Congress didn't intend to take the Commission's discretion away when it never addressed the issue of how compassionate release motions should be treated in this gun situation when they're taking the stacking away. And it certainly has a profound effect on the one issue we know Congress wanted in compassionate release cases to be considered, length of sentence. The whole idea of compassion, obviously, is to bring compassion by lowering the amount of time that a person is incarcerated. And so it makes logical sense that if you're going to consider any legal change, it would be one where society has demonstrated a will to decrease the amount of incarceration time for persons who might be subject to that kind of principle. And that makes sense for the totality of the circumstances that a district court would be obliged to take into account in looking at the other individual circumstances that are relevant for the person. Mr. Chief Justice, you raised the question about kind of a floodgate of problems, but let me address that by saying there are three institutions that are relevant here. There's obviously the Sentencing Commission, which takes into account data and looks at real cases. There are district courts that are entrusted with dealing with these kinds of factual matters all the time. And then there is appellate review under an abuse of discretion standard. Appellate courts have exercised the reversal power under abuse of discretion where district courts have gone too far. And I would point the court to a Sixth Circuit case called United States versus Bass, in which the Sixth Circuit said the district court had gone too far in the post-COVID situation because it allowed for the reduction of a sentence of someone who had been committed to life imprisonment for committing several murders and involved in conspiracy for other violent acts, and the Sixth Circuit said that was an abuse of discretion. So our view is that although there may be some motions filed, and in the fiscal year 2025, approximately 2,000 motions for compassionate release were filed, only 56 were granted under this B6 provision. That statistic is in the clinical law professor's brief at page 17.